Okay, so tonight we're going to have presentations by 4 groups, namely the number 1 group, the Brisbane Group, the Foster-Lech-Pooler Group, as well as the Tiger Group. It's meant to be in that order. I had a discussion earlier with Stephen White, who belongs to the number 1 group, and the suggestion was for his group to be the first to do their presentation. I can't remember who the other group members were of the number 1 group. Would you care to identify yourselves? Who might be the other members of the number 1 group?
It's me, Manjo.
Dean and
me, Manjo.
who was the other one?
Me, Anthony.
Anthony, okay. So there has been a request from Josh, who belongs to the Tiger Group, for them to be the first to do the presentation. What do you think about that request?
I don't think Stephen's going to be able to make it to join us tonight anyway, and he was the main reason why we were going first. So happy to let Tiger Group go first.
Okay.
If you agree then.
Okay, very good. Okay, so we will have the Tiger Group to do the presentation first. This is the group of Josh Zand. I hope I pronounced your last name, Josh, properly. And then we have Greg Mining as well, who belongs to the Tiger Group. They will be the first to do the presentation, to be followed by the number 1 group, the Brisbane Group, and then finally the Foster-Lech-Pooler Group. I'd like to remind the group members that given the fact that there are 4 of you doing the presentation, we need to make sure to follow and observe the time constraints. So each group is given only 12.5 minutes to present, so which means that we're trying to finish all the 4 presentations within the 1-hour time slot for our tutorial. I am prepared to extend it a bit, but please note that I have another class at 7:15, and I have groups presenting there as well. So if there is going to be an extension, it will only be for a couple of more minutes, but not beyond that. Which means, therefore, that each group is given 12.5 minutes, and out of that time, 7.5 minutes is devoted to the presentation, to the factual background, and whatever discussion questions and other points that the group may wish to discuss. And then I'd like to retain about 5 minutes for me to provide my feedback and then ask questions as well. So I'm very happy that we have 4 groups presenting tonight, notwithstanding the fact that today is actually the deadline of the final individual research essay. And I also noticed that there are some other members of the class who are actually here, even if they're not presenting, like Tony Birch, I suppose. You've already presented, Tony. Your group has presented. And that, in that case, I would assume that you've already submitted your individual research essay. And I'm very happy to take note of that, because I would have assumed that a lot of you might be scrambling to beat the deadline. And that obviously is not the case. And that is very good to know. Okay, so before we begin, would any of you have any questions, any comments? None? Okay, so I'm going to be taking close note of the time. If I tell you that, you're getting quite close to the time that has been given to you, it is not meant to be rude, but I want to make sure that those who will be presenting towards the end of the tutorial is also given the proper time allowance. So if I try to interrupt you, it is only out of concern for the other group members who will be presenting tonight as well. Okay, so I'm going to give the floor now to the group of Josh and Greg. And I'll give them the opportunity to share their screen. So I'm going to pause my sharing now. Oh, it's my first time to have seen Maria Pancho.
Hi, Manjo.
Hello, Maria. Hi. What's your nationality, if I might ask?
Filipino.
Oh, interesting. So we're the same then.
Yes.
Manjo is not a Filipino last name, is it?
No, not I guess a typical Filipino surname, but okay. Yeah. I don't know I don't know the history of my family, so.
Okay. Yeah. Okay.
Yeah.
Because you've been my student quite a number of times, I think, and this is actually the first time for me to have seen your face.
Yeah. I just, with work, it's so hard for me to sort of attend the Zoom presentations, but I do rewatch them and everything. So
okay, very good. So hello.
Hello.
Thanks. So I'm going to give the floor to Josh and Greg now to do their presentation.
Hi, Manjo. Josh Zandy and Greg Marnie. Our presentation this evening will be on land acquisition, mainly the Commonwealth legislation and a slight comparison to the Queensland legislation as well. So I'm going to have a go now at sharing our screen. So just bear with me. Hang on a second. I'll just bring up.
Yep, that's the one. Well, good day, everyone. Look, I hope you can see that our factual background was about a case that's occurred in November last year. The federal government is looking to acquire extra land based on an agreement that they had undertaken with the Singaporean government for land in Townsville, west of that city, and also west of the training area called Shoalwater Bay, which is about 100 kilometres north of Rockhampton. And as you'll see, there was an existing training area, and you can see two patches of the likely expansion area. The government there got themselves into a lot of media trouble, as you would have seen in the press recently. And our story is about how the Compulsory Acquisition Act that the federal government operates is different to what we would undertake in the state of Queensland. And we'll talk some more about the comparison of that tonight. But the story detailed a Queensland grazier. She was in the firing line. She got a notice out of the blue. The notification came through very quickly. It was to be run by the Department of Finance. Their letter said, look, you actually can be bought by the government, or we can compulsorily acquire you. And that pressure forced all sorts of politicians, from the Minister of Defence, the Deputy Prime Minister and the Prime Minister, to get involved. The latest is last Tuesday, the decision was made by the Prime Minister to acquire by negotiation. But under the Land Acquisition Act for the Commonwealth, 1989, they have a two-pronged process, and they also have a merits review process under the Administrative Appeals Tribunal, and also the Judicial Review process under Administrative Decisions Judicial Review Act. So it's been a very interesting case. We've been studying over the last three months with Manjo prompting us, and we've learned a lot in that case, particularly because the Federal Act has been influenced by the Kerr and the Brand committees, and also the Ellicott committees. And Ellicott ended up becoming the Solicitor General and then the Attorney General when he got elected to Federal Parliament. And he instituted the two acts, the Administrative Appeals Tribunal Act in 1975 and the ADJR, Administrative Decisions Judicial Review Act, 1977. So, Josh, what would you like to talk about?
Yep. So I'll be talking about, just let me find it on here. Let's go there. Okay, so the Constitution obviously comes first in any sort of legal standing. So the section we'll be talking about is Section 51, number 31. And that states that any government has the power to take, acquire land on just terms within the power to make law. So what that consequently does is bind every government and lawmaking process below it to this idea of just terms, which consequently creates it creates an administrative step for the government to come to an agreement with the interest holder before the land is acquired. And that personally is a great step for anyone that's having their land acquired compulsory, because it gives them some sort of step as to negotiate with.
Yeah. And
from that, from the Constitution, if we then go to the Land Acquisition Act of 1989, I think it is, Section 28 and 29, within those two, there is an administrative review process that further gives the person getting their land acquired a step above the ADJR for an administrative review. Now, I'd like to leave that one there and pass back to Greg about how the Acts influence the change of compulsory acquisition.
So what's occurred is that the Land Acquisition Act had that two-pronged process, and in 1989 the Land Acquisition Act was, as the assent went through the federal parliament. In November of that year, the Leppington pastoral case came into fruition, and there was an appeal on...
You've got 3 minutes left, please.
Yep, thank you, sir.
Yep.
There was an appeal to the Administrative Appeals Tribunal under 28 or 29 Land Acquisition Act, and it based its question to the AAT on Section 22(5) of the Land Acquisition Act, saying that the federal government didn't have the rights on the particular policy to acquire the land. The tribunal member, he actually referred under Section 41 of the AAT to go to, it might be 44, I beg your pardon, to go to the federal court and ask the federal court for a judicial decision whether or not he had the power to act on policy. That case occurred 6 months later, and the decision was handed down in June 1990, Leppington Pastoral Company case, and it was for Bringelly and for the airport in Sydney, the second airport, and that decision was no, the AAT did not have that power. Interestingly, the Department of Finance told me that only 3 compulsory acquisition cases have ever been referred to the AAT. Josh.
Okay, so finally we'll probably, we're just going to highlight some other cases apart from the one in 1990 there. What I recently studied in my individual assessment was the case of Judicial. Now, it's a Northern Territory case where the government came in and acquired land that was leased from the Aboriginals under a land trust. Now, what was interesting about that case is that it didn't fall under the legislation that we spoke about earlier of 1989, which, by the way, is a really well-written act. It constitutes everything to do with that. What they instead tried to acquire the land under was called a National Emergency Response Act, which had 2 sections that responded to the acquisition of land.
30 seconds.
And it consequently resulted in like an acquisition of the land and just referring people straight back to Section 51 of the Constitution. So what resulted from that was this massive discussion of what just terms actually meant.
Josh,
and
sorry, I have to stop you there because...
No, that's all right. That's okay.
Time. Okay, so I'm just going to give my comments right now. It's quite obvious to me that, both Josh and Greg are quite articulate, and I'm actually quite happy with the way that they presented the case facts and some of the law. And and so, you've got the makings for oral advocacy, which is really good. My only concern is that when you use visuals, especially PowerPoint slides, for example, what you really need to avoid is overloading these PowerPoint slides with so much information, perhaps with the expectation that the viewers or the listeners are meant to be reading them at the same time that they're trying to listen to you. So in the future, you have to make sure that you should summarize and come up with just main bullet points in your PowerPoint slides. Because otherwise, if a listener is trying to listen to you and at the same time reading through what is written there, that leads to cognitive overload, and it's just so difficult. Yeah. So that is the main concern. That's the main constraint that I've seen here. And okay, so I'm just going to skip the feedback now because I'd like to ask some questions, if that's all right. Sure. I'm not too sure what exactly is the administrative decision here that we're trying to grapple with. It's not clear to me.
Well, it's a very interesting point you raise. Normally, Act the compulsory acquisition powers are enacted by a government and they don't negotiate. The political position, because of this defence land, has allowed the government to avail itself of Section 20 of the Land Acquisition Act, which gives people the ability to follow the process of negotiation. And so the Land Acquisition Act 1989, its previous iteration had none of these administrative review capabilities or these abilities to negotiate.
Apologies, I don't want to be rude. I'm just conscious of the time. I'm just going to have to stop you there.
Sure.
Deal with administrative law, and especially if we're trying to determine whether or not there is an opportunity to seek a merits review or even a judicial review, we need to be dealing with somebody who's been affected by an administrative decision. So there was an attempt earlier in trying to identify a potential aggrieved, somebody who could have been affected by an administrative decision, especially because when you drew the map, you spoke of a particular land. So it is crucial, if you're going to speak of an administrative law decision and potentially whether or not there is a possibility of undertaking or applying for judicial review, merits review, you need to identify who the specific person is who has been affected by an administrative decision, and therefore also determine what the administrative decision is. So in this particular case, that is not too clear to me. Now, it is very dangerous if you're speaking of an administrative law matter, for example, to be then speaking broadly about a group of people, because in that case, if you say that there is a legislation which broadly affects people, I'm not exactly sure if then we were dealing then with an administrative decision. And in fact, it appears to me that we're looking at the broad application of a law, in this case, the Compulsory Land Acquisitions Act, passed by the Commonwealth Parliament, which then broadly affects a certain population. In that case, the recourse is not to go to the AAT, because that is not an administrative decision. What you end up seeing is the application of a law. And potentially, if you bring in the courts, it will be to question the constitutionality of the legislation. And I'm not sure, you want to respond to that?
What I would say, Manjo, is that the negotiation process, if it fails, they are able to go to the AAT.
Yeah, so that's good. But
this process is very live. This particular example we've used is live. It's happening now. It's very topical. And so that's why we wanted to examine it, because it was very fluid.
Right. But who exactly is the person who is affected by this decision?
So in this particular background case, there was a woman noted on a property called Kuti Uti, and they adjoined that particular map.
Jack, can I butt in here? Sorry, mate.
Yeah.
I think the answer you're looking for, Manjo, is the people that are affected have had their particular interests taken by the government, and that in hand then enacts Section 5 of the ADJR. I think it's Section 5.1 for natural justice.
Okay, so there are two things, at least three things, I think we need to clarify, and I'm hoping, I don't know if you have the time to address the individual research essay. You need to identify the aggrieved. You need to identify what the decision is. You need to identify the decision maker, because Josh, what you did so far was to speak of the government deciding. I'm not sure who the government is. Is it the Commonwealth Parliament you're speaking of, or is it a specific administrative agency belonging to the executive government? Because it has to be a decision made by the Commonwealth Parliament, because that is not an administrative decision. It has to be a decision of the executive. Okay?
Yeah.
It's just Now, apologies, but I'm going to have to end it there.
That's fine.
So I hope you take on board the comments I made.
That's great.
Because you need, constitutional law focuses, for example, on the exercise of power by one of the three branches of government. So it could be the executive, meaning one of the administrative agencies, for example. It could be a member of, it could be a minister of the executive. So that's the executive government. You have the Commonwealth Parliament, then you have the courts. So it becomes a constitutional law question if the focus is really on whether or not there has been a proper or valid exercise of a power by one of these branches of government. That is a constitutional law question. Now, if we speak of administrative law, we're dealing with a decision made by part of the executive or an administrative agency that specifically affects a specific person. Because we will recall that the moment that there is a decision, even by the executive, but it broadly affects a population, chances are that no longer becomes an administrative law question, that becomes a constitutional law matter. Because it is a requirement, if it is an administrative law decision that we're speaking of, that the aggrieved must be able to specifically identify whatever right potentially has been affected by a decision of the administrative agency or an administrative body.
Understand, Manjo. Thank you.
Okay, so thanks. Thank you for the presentation. It was very good. I'd like to move on now to the next group they will be presenting, and that is the Brisbane Group. Thank you, Josh, and thank you, Greg. We're going to have number one group presenting.
Oh, group one?
Sorry, group one.
Have you got the slide there, Manjo, or do you want us to share it?
Please.
I've got a plan. I'll share it.
Okay, thanks.
Okay. I'll just wait for you to share it and I'll start.
Is that coming through?
Yes.
Yep, that's fine. Thank you. So I'll just get started. Like, what's really started all this was in January 2016, Lucy had her family tax benefit A cancelled because her children were not immunised. And so she's wondering whether the decision that was made by Centrelink is able to be challenged, either with a judicial review or a merits review. So just some background. Immunisations have long been part of the fight in Australia against disease. In fact, according to the Immunisations Australia program, Australia has a high immunisation coverage of over 90% of children fully immunised between the ages of 1, 2 and 5 years of age. And the Australian government adopts what's called a herd policy or immunisation policy, which is intended to reduce the outbreaks of disease. Of course, the goal of any good government is to promote health and eradicate preventable diseases. So to further that aim, what the federal government did, which was enacted in 2016, was they created the National Immunisation Program Schedule. That's been going for some time, I should say. And that's a fully funded program which provides vaccines and booster shots for children in Australia, and it's been going on for years. Now, currently, compliance is presently voluntary. Parents and guardians still have the legal right to refuse for whatever reason. But just recently, there's been a subtle change that's began to chip away at that right. In January 2016, the federal government, they introduced a new requirement. This was through the enactment of the No Jab, No Pay Act, and it attached 2 new conditions to receiving some benefits, particularly a child support benefit and a family tax benefit A. And those 2 conditions were that a guardian or parent wanting to receive those supplements or those benefits must have children immunised as per the National Immunisation Program. And secondly, they have to provide Centrelink with the child's Medicare number for verification processes. Now, the only exemption that's available is for approved medical conditions or reasons, and conscientious objection to immunisation for any reason is considered invalid. A failure to meet the conditions means a refusal of the benefit. Centrelink is the federal government executive department which makes the determination. So why is this important? Well, since many people have been affected by the policy of linking benefits to immunisations, including LISA, we wonder whether this can be challenged through judicial or merits review. And really, that's an important question. So what I'm going to do now, there's three of us in this group. One of our members is not able to attend tonight, so I'm going to hand straight over to Anthony, and he's going to cover the other issues.
So the main administrative point of law relation to a person's eligibility for government financial assistance at a federal level as it relates to child immunisation is that of the executive exercising a power on the granting of these payments through way of a legislative instrument. If we compare this to the state level, it's the Public Health Act 2005, which provides early childhood education and care services powers relating to enrolment and attendance of children who are not current with their immunisations. So if we go back to a new tax system, Family Assistance Act 1999, and the Australian Immunisation Register Act 2015, it reveals that the term legislative instrument, as exercised by the Minister, is used freely throughout both acts. And the legislative instrument in question is the Family Assistance Meeting the Immunisation Requirements Principles 2015. And that's also been registered as a legislative instrument on the Federal Register of Legislation. So as Dean said, over the past year, the family assistance principles have been used by Centrelink to cancel or deny the family tax benefit to families that cannot prove that their children are immunised according to the published schedule. This is to be taken as an administrative process on this matter. Then the question is raised of the apparent discretion given by this legislative instrument to rule on whether a family will receive the FTB Part A end of year supplement, the childcare benefit and the childcare rebate, all of which are denied if they don't meet those immunisations. Thanks, Manjo.
You've got 3 more minutes.
Okay. The issue is compounded by the fact that there are contradictions within the relevant legislation. For example, the Australian Immunisation Register Act, which itself isn't a legislative instrument, establishes guidelines for checking vaccination status, but provides a contradictory mechanism which is supported by the family assistance principles. So the family tax benefit is an extensive government welfare program, and it represents a significant proportion of the government's total budget. In fact, it was nearly 5% of government spending in 2014. So in adverse fiscal circumstances, it's not difficult to imagine that the no jab, no pay legislation could be framed as a convenient cost-cutting measure justified on the basis of public health. Opponents to the legislation have based their arguments on it being an unlawful exercise of administrative power and even argue that it is unconstitutional. However, challenges based on legality have not made it to the courts. The question is therefore whether the enactment of legislation is the right thing to do. So whilst there might be a manifest incorrectness with regards to legislation based on the preservations of the rights of the individual, I'd say it would still be insufficient to trigger judicial interference on the basis of the Wednesbury test. As was established in that case, the courts won't interfere with the executive purely as an arbiter of correctness. So if we consider this situation against the principle of natural justice and procedural fairness, we must then consider whether the redress mechanism given for someone to make their case against a decision actually exists and whether that decision is made without bias. So whilst there are currently mechanisms in place for a review of this decision, and that satisfies the first element of procedural fairness, we argue that the desire to trim the budget bottom line has lent bias to the government's decision making, and thus this has also made its way into the instruments used to guide the administrative decision makers. Holistically, the immunisation issue brings into sharp focus the onus upon the government to resolve issues of collectivism versus individualism. In considering the No Jab, No Pay Act, the government is hit with this dichotomy twofold. Firstly, do the rights of individual freedom and medical consent free from coercion outweigh the benefits afforded by immunisation? And is the denial of welfare to those in need an appropriate price to pay for ensuring the health of the population? Those are our questions out of this. Manjo, what are your questions for us?
Okay, thank you. So let me just give my comments. I'm very happy with the way that this group used visuals in the presentation, which really enhanced the ability of the presentation to really engage the viewers. So that's really good, and it's quite clear that the group came well prepared, and the way that you did the presentation was also done in a very relaxed manner. So, and you know, you've also spoken in a way that allows the listeners to really listen well to what you're saying and understand what you're saying. So those are the good points. Now, my main problem with the presentation really is really in relation to the content again of the presentation, because it is not clear to me what the administrative decision is. And in fact, the way that the presentation was made, it appeared, in fact, there was a statement earlier by Anthony where he talked about the incorrectness of the legislation. So it appears to me that the focus of the presentation was the potential incorrectness of the legislation itself, or perhaps the invalidity or the unconstitutionality of the law. And in fact, I'm not sure if there is such concept as the legislation being incorrect. As far as an administrative decision is concerned, potentially you can argue that the decision is incorrect on the basis of the facts, but you cannot make a case as far as legislation is concerned that the law is incorrect. Because at the end of the day, if the Commonwealth Parliament has the power to legislate, then it can legislate however it likes, subject only to constitutional constraints in relation to the separation of powers, or perhaps to both the express and implied rights and freedoms under the Constitution. And so therefore, the focus of any administrative law discussion should always be about an administrative decision that affects a specific person. And in this case, I'm not sure what it was. So let me just therefore ask two questions. Number one, who is the person who is probably affected? So who's the specific individual whose interests are affected by an administrative decision? That's one. Two, what exactly is the administrative decision? And thirdly, if there was an attempt to apply for a review, either on the basis of a judicial review or a merits review, what would be the reasons that will be cited in that application to impugn the validity of the administrative decision? So who is the person affected? What is the administrative decision? And on what grounds or what reasons will be cited if you were the solicitor to question the correctness or even the lawfulness of the administrative decision?
Well, the person or the individual affected is Lucy. The question is whether she can, the decision was to remove her benefit. So the question is whether that can be challenged. That's something that she can actually challenge. And yeah.
So there was a decision that was not in favor of Lucy, which was against Lucy. So that's good.
Yes.
But what exactly was the administrative decision there?
Well, she was receiving family tax benefit A,
Okay.
and she had that suspended,
That was suspended on the basis of the law.
On the basis of the new legislation.
Okay, so in that case, how will you attack? On what grounds? I mean, what reasons will you cite either before the court or the AAT to impugn the validity of the administrative decision?
Well, we would have to look at. Oh, sorry, Anthony.
So in that case, I guess the error we've made, Manjo, is that, or the error I've made is I've considered it too broad. In the research, I looked at what opponents to the legislation have put forward as the rationale for their opposition, and then compared how that fits within the principles of administrative law. So pointing to whether such a challenge would be valid on the basis of unreasonableness, or whether it would be able to be challenged on the basis of procedural fairness.
Yeah.
But probably too much of a treetops view of what was to be examined rather than getting down into forming the legal argument either for or against such a challenge.
Yeah, you have to make a distinction whether you're attacking the legislation itself, which is, I think, what you seem to be suggesting, because that is a constitutional law question, as opposed to attacking an administrative decision because it probably offends the law, or it affects an individual, and which is probably contrary to the law or contrary to the factual evidence. And so,
Manjo,
yes.
Yeah, if I can just say, the issue really would be, has Centrelink obeyed the law in following, in cancelling her benefits? So,
Very good.
So
That's
we
good.
need to look at the legislation itself.
Yeah.
And see that there actually is some justification, or I should say full justification, for Centrelink to actually do that.
Correct.
And if there is, then obviously we wouldn't be able to challenge that with a judicial review. So then that takes us to the merits review, and we can only challenge it in a merits review if a merits review is allowed for in the legislation, i.e., in a new tax benefit.
So that's good. That's a lot better, Dean, in the way that you presented it. And in fact, I would have wanted to ask you because you cited the fact that there were two laws that were potentially conflicting. They were contradictory. And assuming that there was a decision that was made against Lucy, and you could argue that there were two conflicting provisions based on two distinct laws, then in that particular case, can you make an argument that the decision reached then should be subject to a judicial review and not a merits review? So that's my question now.
Well, in that case, because you're speaking to the correctness of the law and resolving an issue of law.
It's not the correctness. When you speak of correctness in relation to the factual decision, when you speak of the law, you're speaking of the lawfulness of the decision, or the lawfulness of the decision.
That's poor terminology on my behalf. I guess it is the question of law contradicting itself. So that to me would be a judicial review because it is a question of law.
Okay, good. So I'm gonna end it there because we've kind of exceeded the time. I wish we had this presentation sooner because it could have enhanced. And I'm hoping you address it anyway in the individual research essay. But I did highlight this in my comments, I think, in the group discussion. So having said that, I thank the group for the presentation and take on board the comments I made to make sure that we don't conflate, we don't confuse constitutional law from administrative law, because these, although they're related, these operate in distinct fields of law. Okay, so thank you, Anthony and Dean. And I'd like to give the floor now. So thank you for the very good presentation. I'd like to give the floor now to the Brisbane Group.
Thank you, Manjo. Okay, good evening. My name is Maria and I'll be presenting on behalf of the Brisbane Group, which consists of Thomas and Melissa. Melissa is unfortunately absent today, so it'll just be Thomas and myself. So we, the Brisbane Group, have identified an issue relating to drug users whom attend medical treatment for their addiction. This issue raises a rather unknown fact that most will be subjected to investigations by the Crime and Corruption Committee. These investigations gather rather self-incriminating evidence that may be potentially used against such individuals. However, there are administrative law rules that prevent such self-incriminating information to be used, and this is where our factual issue begins. At Gold Coast Hospital, which is a major public health facility, the staff have reported an increase in the number of patients requiring medical treatment due to the adverse reactions to the zombie drug Flakka. This drug is a synthetic hallucinogen which combines the effects of LSD. Illicit drug users on the Gold Coast inevitably became patients of the hospital and sought treatment primarily as a result of being brought in by emergency ambulance services due to substance abuse. In response to an alarming increase in drug-related deaths on the Gold Coast, the Crime and Corruption Commission and other law enforcement agencies have recommended that persons affected by illicit drugs should use these public health facilities for medical treatment. However, with the implementation of policy enforcement by the CCC, patients are compelled to answer questions about where they obtain their drugs, and has resulted in making people reluctant to call an ambulance or to seek help from a hospital because they face the prospect of being charged and imprisoned for non-cooperation. Despite its counterproductive effect, the CCC continues to use this policy enforcement to assist the Queensland Police Service in their investigations. The ABC reports that 2 men were recently arrested and charged with drug supply after patients at the Gold Coast Hospital gave evidence about them. John Douglas was one of the 2 men arrested and charged by the QPS with help from the CCC. Before John Douglas was placed on trial, the Department of Public Prosecution made a request to the Executive Director of the CCC to release documents which were obtained during the investigation. The decision was made under Section 213 of the Crime and Corruption Act. The events of the factual issue raises the legal issue of the legality of the executive of the CCC's decision to disclose evidence taken from the coercive hearings conducted on John Douglas to the Department of Public Prosecution. The Crime and Corruption Commission is a statutory body set up to combat and reduce the incidence of major crime and corruption in the public sector in Queensland, and is appointed by the executive government. As a statutory body created by the executive branch of government, the CCC is granted special investigative powers that are not available to the police or any other government agency in conducting an investigation. These include power to conduct coercive hearings and to hold public inquiries. In light of the events from the factual issue, the CCC, in its efforts to combat drug-related activities, have administered their coercive powers to help police investigators. Under the Crime and Corruption Act 2001 Queensland, the CCC has the power to hold 2 types of coercive powers hearings, which are coercive hearings and coercive intelligent hearings. These coercive powers provide the CCC with the power to call witnesses to these hearings and compel them to answer questions and or produce documentation. Coercive hearings enable CCC investigators to override the right to silence and the privilege against self-incrimination. This allows them to secure otherwise unobtainable evidence, including intelligence regarding activity by criminal organisations. Information garnered from these hearings may have been otherwise inaccessible to investigators following standard police investigation procedures. It can be said that the administrative law rules which encompasses administrative decisions and which applies to the facts of the issue can be found under the concept of judicial review. Judicial review is not the rehearing of the merits of a particular case. Rather, it is where a court reviews an administrative decision to make sure that the decision maker used the correct legal reasoning or followed the correct legal procedures. Whereas merits review is available in relation to decisions specified under the Administration Appeals Tribunal Act 1975, judicial review is available for all decisions of an administrative character. The concept of judicial review is to determine the legality of the exercise of power by administrators and tribunals. If a court finds that a decision has been made unlawfully, the powers of the court will generally be confined to setting the decision aside and remitting the power to the decision maker for consideration according to law. There are 2 sources from which the grounds for judicial review may be found. These are in common law and statute law. The grounds established in common law and statute law for the administrative law rules in relation to the legality of administrative decisions found in the concept of judicial review ensures that the government officials are restrained by the law and act according to the prescribed boundaries that the executive power provides. Most, if not all, grounds of judicial review are concerned either with the processes by which a decision was made or the scope of the power of the decision maker. The common law judicial review covers some areas of administration not covered by the Administrative Decisions Judicial Review Act 1977, such as decisions not made under enactment. The source of judicial review under statute law can be found in the Judicial Review Act 1991 Queensland. The Act provides an avenue for a review of decisions of those exercising state government power, where the Queensland Supreme Court does the reviewing under the Judicial Review Act. Part 5 of the Judicial Review Act provides common law and equitable remedies, as the Administrative Decisions Judicial Review Act 1977 is not available for decisions made by a state government. The key terms for the review are that there is a decision to which the Act applies and there is an aggrieved person. The key terms for a decision to which the Act applies is that there must be a decision of an administrative character under an enactment. Thank you.
Oh, thank you. Thank you, Maria. Why didn't you use any PowerPoint slides?
I'm not too sure. I assumed that it was just a straightforward presentation. I didn't even consider PowerPoint slides at all.
Yeah, it would have been helpful. Actually, it was just your group so far, and this is going to be the last one that did the presentation without the PowerPoint slides, because the PowerPoint slides always help to capture the interest of the viewers, especially if you use visuals like the group of Dean and Anthony did earlier. So it captivates the attention, and it helps you oftentimes focus on key issues on the basis of image. As they say, a picture paints 1,000 words. So a single picture or image can be really important in conveying certain information. So that's one. Secondly, the PowerPoint slide can be used to telegraph or to convey critical information, which are main information, which could be the basis of a summary of certain information. And instead of compelling the listener to closely follow what you're saying, it enhances the ability of a listener to understand what is being said if he has an opportunity to both listen to you and kind of, in a sense, validate what you're saying on the basis of what is shown in PowerPoint slides. So I just saw that as a limitation. But otherwise, I'm very happy the way that you've presented it, because you're obviously quite articulate, which is good. You're very, very articulate. You speak really well. That's good. Now, the main problem, again, that I have would be two. The first one relates to my inability to clearly identify what the administrative decision involved is. You did mention John Douglas as a potential aggrieved, but it wasn't clear to me what the administrative decision was. So I'm going to give you a chance later on to elaborate on that. But having said that as well, the other common shortcoming I've seen so far, I think across the three groups that have done the presentation, is that while there has been often a discussion of what the laws were, the laws are often discussed in the abstract without really clarifying why the laws are relevant to the factual background. So when you discuss the laws, they're meant to be relevant to the factual background. And in fact, before you can start discussing whether the laws are relevant to the factual background, you need to therefore identify what the legal issues are, because the legal issues will determine what laws are relevant. So in other words, if all you do is you talk about executive accountability or the need for national justice broadly, then we don't know, why are we even discussing that? So in other words, if you're talking to a client who has a specific case to you, and what you then end up doing is to talk about administrative law in general, it is unhelpful to the client. The client would like to hear from a solicitor, this is my problem, this is my factual background, so what are the laws that potentially could impact my case? So we're talking of laws that are relevant to the factual background, because otherwise, if you're talking of laws in general, and which are probably even unhelpful in trying to determine whether an administrative decision could be the subject of either a merits review or judicial review, then that is a very unhelpful and irrelevant discussion. And to me, that is my concern, because when you discuss the laws, they were not clear to me what they had to do with the factual background. So let me begin by asking some questions here. So first, what exactly is the administrative decision? And if there was an administrative decision, was the administrative decision based on a Commonwealth law, or is it a state law? Let me just begin with those two questions first.
Sorry, Manjo, is that directed at me?
Yeah, that was directed at you, Maria.
Oh, sorry.
So I had two questions there. So one,
Okay.
What exactly is the administrative decision that we're dealing with here? And I suppose that has something to do with John Douglas. So what exactly was the decision, the administrative decision? And second, what is the basis for the administrative decision? Is that on the basis of a state law or a Commonwealth law? Thomas, did you raise your hand? You're going to have to unmute yourself if you wanted to say something. Thomas, you have to, I could unmute you if you like. If you wanted to say something, hang on, where's that? I'm having a hard time finding it. Thomas, you're going to have to unmute yourself if you wanted to say something.
Can you hear me now?
I could hear you now. Go ahead, please.
Yeah, the administrative decision was made by the executive director of the CCC.
Mm-hmm.
And it was her decision to disclose the information from the CCC's coercive hearing to the Department of Public Prosecution.
Very good. Okay.
That was the administrative decision. And Section 213 of the Crime and Corruption Act prevents an executive of the CCC from doing that. That's the illegality. It was the illegality of the executive director of the CCC to disclose that information to the Department of Public Prosecution.
Okay.
It's would be similar to the CCC investigating me and perhaps pressuring me to make a certain disclosure of possession of drugs or drug trafficking.
Okay.
And then using that information to directly go to the courts via the Department of Public Prosecution. And that's an illegal procedure. They have to give that information to the police, and then the police have to obtain a warrant, and then they go through the proper procedures of investigating and seeing if I did actually have
very good, Thomas.
Drugs in my possession. So it's an illegal decision and an illegal procedure, and it denies people proper due process. And as you know, due process is the most important common law right that any citizen has.
Okay, so that's quite clear. Very good. It wasn't clear to me initially, and I had to go through your factual background many times. So that's good. Now, the question I'd like to then ask is, because you talked about due process, and in fact, in your factual background, you talk about self-incrimination as well. Now, the question I have is, if we say that these are common law rights, can they not be displaced by statute, such as by the state? And if so, can you still impute a decision that does not recognize these common law rights because they have been displaced by specific statute? Where's that coming from?
Yeah.
Okay.
Well, the CCC it does have these coercive powers, and it's not only Queensland, but all of the states have these coercive powers, and they do have a right to investigate, suspected criminals or people suspected of organised crime, but they don't have that right to use the information from those coercive hearings to aid and abet the State Department of Public Prosecutions
let me just
in their prosecution.
Yeah, let me just stop you there. What if the law actually provides that one of these administrative agencies of the state can do it? Would that make the law invalid? Is that the point?
Yeah, it would, because it impinges on people's common law rights to due process.
But that, back to that point, Thomas, if you're speaking of a common law right to due process, for example, or even to the right of self-incrimination, if it is a common law right, it is a right recognized by the courts. And conventionally, it means that a common law right can be displaced by an express provision of the law. So even if the courts recognize that there is a right against self-incrimination or even a right against due process, if a legislation says that there can be no due process, if the law says that there can be no right against self-incrimination, you cannot impugn the validity of that law. So if that were to be the case, what situation do we have then? Or are you saying that the common law right will override the power, let's say, of the state parliament to pass legislation to actually not recognize the right to due process and the right against self-incrimination.
Yeah, okay, I think I understand better now. Yeah, what it is, Section 213 of the Crime and Corruption Act actually explicitly states within the legislation that they are prevented from doing that very thing.
Which is
the only time that sorry,
when you say prevented from doing that very thing, what is that very thing?
From disclosing information from the coercive hearings. They're prevented from doing that. What the executive director is permitted to do is they're able to be called as a witness in a trial, and they can give evidence as a called witness. But what the executive director did, she just disclosed this information, but it wasn't actually within the courts. It wasn't made under oath, and there was no oral testimony attached to that. Good. She just simply disclosed the information straight to the department.
Very good.
And they went ahead and started to build their...
apologies, I'm going to have to stop you there because I'm aware of the time. It's almost 7 o'clock. Let me just make a clarification here. Especially because we're dealing with state legislation, we have to be very careful in asserting that the legislation is invalid, because state courts actually do not have the power to invalidate state legislation in general, unless it goes against the Commonwealth Constitution. Because in state courts, there is a recognition of the supremacy of state parliaments. And so in general, state courts don't have the power to invalidate state legislation unless they are against the Commonwealth Constitution. So just be careful there. So in other words, if the state parliament passes a law, for example, which compels a person to incriminate himself, because the right against self-incrimination is not a constitutional, it's not a right that is protected by the Commonwealth Constitution, the state parliament has the power to do that. And it cannot be invalidated by a state court. So just be wary. Just be aware of that. Okay? Any questions? So I'm aware of the time. Feel free if you have any questions on what I have just said. And I'd like, so I acknowledge, well done, Thomas, in answering the questions, and Maria as well. And I'd like now to move on to the last group that will be presenting, and that's the Foster-Pooler Group, who will be Foster-Pooler Group. They'll be making the presentation. Thanks.
Hi everyone, how are you? You guys see our slides? Can you hear me? Hello, can you guys see our slides and can you hear me?
I could see it. I suppose the others could, yes.
Okay, so our group, unfortunately Craig couldn't be here tonight, but in our group tonight presenting will be myself and Heidi Pooler. I can't see that slide, Heidi. Anyone else see the slide? Thank you. Yep, so our administrative law problem focuses on a particular case, and it's to do with the Migration Act. So can I have the second slide, please, Heidi? So our case, or our scenario, revolves around a gentleman called Aaron Graham. He is a New Zealand national who came to Australia when he was 10 years old. And he has been in Australia for a long time because he's now 49. He's in fact married in Australia and had children in Australia. He did not have a permanent visa. He was a holder of a subclass special category visa. He has a long history of criminal offences dating back to 1985, which include theft, drug possession, firearm offences, and more recently a 2009 assault charge. He's a member of the Rebels motorcycle gang, and in fact he was the president of the chapter in Tasmania, in Kingston, I think, where he's from. In July 2011, the minister warned him that his visa was at threat of being cancelled, and he acknowledged... oh, Heidi, can you go back to our slides? Yep, and he acknowledged that that threat. In 2014, I think that the minister probably would have cancelled his visa anyway, being given the chance, but in 2014, there were quite a few changes that broadened the application of the Migration Act, which Heidi will talk about in a little while. But the minister actually revoked his visa. He applied for a judicial review via the federal court. Merits review is expressly precluded in that legislation. So he applied for a judicial review, and the order was actually quashed. So he won. 3 hours later, a new order was issued. There was some discussion about how the minister managed to prepare a 300-page document in 3 hours. So there is some argument there about how they were, how do you put it? I suppose they were preempting what was going to happen. They ignore what the said anyway, because they issued the new order, and Mr. Graham now appeals to the High Court. The other interesting thing is, and I'm not sure, I think it's quite relevant, when the minister cancelled his visa, the minister actually gave him an option and said, I'll give you an opportunity to present your case. But under the legislation, once the minister has cancelled your visa, you have no avenue to do that. So I think that the fact that the minister did that is where his whole argument has some basis now, because they're saying that he erred when he gave him that option. So I think that's where the loophole for Mr. Graham is. So Heidi will now talk a little bit about the Migration Act.
One moment, sorry guys. So the Migration Act, under the Migration Act, Section 5013, which is under dispute, where it states that the minister must cancel a person's visa if they reasonably suspect the person does not pass the character test. So the question is, what is the character test?
Heidi, you get 2 minutes to go.
Yeah, sorry. Okay, so under the character test is provided in Section 5016, subsection B, which states that a person does not pass the character test if the minister reasonably suspects that the person has been or is a member of or in association with a group, organisation, or a person that has been involved in criminal conduct. The provision was amended by legislative change that took effect on 11th December 2014. The explanatory memorandum accompanying the bill states that the purpose of the amendment is to lower the threshold of evidence required to show that a person who is a member of a criminal motorcycle gang does not pass a criminal test. Further, the length of sentences was substantially lowered. Previous to the 2014 amendment, the threshold of a substantial criminal record was 24 months. The memorandum relatively states that the intention is that the membership of the group or organisation alone is sufficient to cause a person to not pass a character test. Further, a reasonable suspicion of such membership or association is sufficient to not pass a character test. There is no requirement that there be a demonstration of special knowledge or participation in the suspected criminal conduct by the visa applicant or visa holder. Just highlighting there that there's no burden on the minister to prove the significant risk to the community, or that the association of the groups were proved to be committing criminal offences.
30 seconds.
So the issue relating to administrative law is where amendments have significantly broadened the amount of people the legislation now applies to. There have been detrimental impacts on natural justice and administrative decision-making and integrity of principles underpinning the criminal justice
Heidi,
system.
apologies, I have to stop you there because it's now 8 minutes and I actually have a class at 7:15. So I'm sorry, I'm gonna have to stop you there.
That's fine.
Yep. I'm happy with the presentation to an extent. I'm surprised, Heidi, why the PowerPoint slides did not come up when you did the.
Sorry, yeah, my computer wouldn't allow me to show it.
I understand that's a technical problem. So I'm glad, by the way, that initially the PowerPoint slides were used, which actually just focused on the key points of the presentation. That's good. So let me just focus now on some questions that I have here. I'm interested in the statement made earlier that by Jane, that a merits review is actually precluded by the Immigration Act. And that surprises me, mainly because the Immigration Act does allow for merit review. In fact, if you look at the one of the divisions of the AAT, you have the Migration and Refugee Division, which actually focuses on reviews of decisions pertaining to immigration. What is the statutory basis for that statement, Jane, when you say that marriage review is precluded by the Immigration Act? Where does it say?
I don't know where I read it, but it was somewhere that those decisions, so the minister doesn't have, it's not his decision. I can't remember where I read it, but the minister doesn't have a decision. It's not his personal decision if the person fits that criteria. It's just if the person meets that criteria, they automatically must have their visa cancelled. And that I'm sure I read that it said that it is not, it's not subject to review.
Not subject to marriage review.
I'm sure that's what I read.
Yeah, it would have been very helpful. And in fact, you're meant to really provide the citation for that. And I do know that I actually flagged that in my comments. I wanted you to identify the specific statutory provision because it is very unusual to suggest that a marriage review is precluded by the legislation, mainly because the AAT has a specific Migration and Refugee Division. So I don't know if it's a bit too late now, but it would be helpful if you could identify that, what statute that is.
I've just written here, and I haven't put the reference, but I've got the Act specifies that a discretionary decision of the minister pursuant to Section 501 is not subject to merits review.
What provision of the law is that?
Section 501.
Section 501. The exercise of discretion.
Yes.
Okay. Now, the decision of the minister can both be based on discretion and can both be based on an interpretation of the law, or it can also be based on the application of the law to the facts. Now, it would appear here that the minister, I think, was not exercising his discretion whether or not to deport, for example, Mr. Graham, but it was actually the attempt of the minister to apply the law to say that he is one of those whose visa should be cancelled on the basis of his substantial criminal record. So in that case, it is not the application of discretion. In fact, it is the application of the law.
Yeah, but that's where maybe I'm wrong. I also thought that it wasn't his discretion. I thought that if you met that criteria, then you automatically had your visa cancelled. There is no discretion there.
So in that case, based on the provision you just cited, that provision is inapplicable because that provision you cited talked about the preclusion of merits review if the minister exercised his discretion. In this case, we're not talking of the exercise of discretion. We're in fact talking about the requirement of the minister to apply the law.
Yes, I see what you're saying.
Yeah, so just have a look at that. Now, I'm also surprised why this went up to the High Court and not, for example, the federal court. Would you know why it went to the High Court?
Well, this is something we've discussed quite a bit, and I was getting into the I even said to Heidi earlier in the week, I feel like I'm getting into the constitutional part, and I know this isn't constitutional law, but I think that it would have. I think a big part of it would be the fact that the minister asked him to put his case forward when that's not relevant. So he's now arguing that obviously something went wrong there. But I'm also wondering, which I'd really like feedback on, we found some of our other slides were about the human rights impact of this. No?
It shouldn't enter into the picture. Because when you start raising human rights concerns, you're actually questioning the legality of the decision. And in a sense, impugning collaterally the Immigration Act. And you've got a problem there in terms of a question of law when you have a situation where you have a specific law passed by the Commonwealth which contradicts another law. And the job of any court is always to try to attempt to reconcile both laws. And that certainly is not for the AET to determine. Okay, so I wouldn't have attempted to bring in, because that just confuses the issue. The other point that should have been relevant really was, I don't know, if there was a potential ground for judicial review, because it went to the High Court, so presumably there was a question of law, and I would have wondered what it was. But if there was a question of law, why wasn't the recourse based on the Administrative Judicial Review Act of 1977? Would you know why?
No.
Yeah, that just confuses me why it went all the way up to the High Court. Anyway, apologies, but
that was all that I could find out. The article that I read was that his, I'll say, I know you're running really late, but I did have, I'll just see if I can. Okay,
but Jane, I'm gonna have to, again, apologies. I have to stop us here because I've got a class at 7:15. So again, when I ask these questions, some of them may be a bit forceful. Apologies for that. Apologies. Let me just clarify. I tend to be forceful sometimes, but my purpose really is hopefully you consider to be sincere, and it's simply an attempt to try to encourage a discussion about these questions that I raise. Okay, so it's.
I think that part of it quickly was because his lawyers are arguing that the minister didn't show how removing him would advance the national interest, and part of that was, and that's one of the things that it says in the legislation, to remove someone that is in advancing the national interest, and they're asking. Well, they're saying that Mr. Dutton hasn't put forward any reasons at all how that advances the national interest.
They were saying that the question of the concept of national interest is a question of law, not a question of fact. How do you define national interest? That is a question of law. I think that's the argument. Okay.
And I think one of the other things is somewhere in that Immigration Act, it also says that the chance that somebody may offend again. And they're wondering, well, how does anybody tell the future? How do you preclude someone from staying in Australia on the chance they might offend again? That is something that may never happen.
Good point. Now, I need to end the tutorial at this point because I've got a class in a minute. So thank you, everyone, for taking the time to be at tonight's tutorial. And congratulations on obviously passing the course. I mean, I can't see a reason why not all of you will not pass. And I look forward to reading your individual research essay, which I would have hoped would have been enriched by the discussion we had at tonight's tutorial. So thanks, everyone, and I hope to see you again in the future as one of my students. Good night. Bye.
Thanks, Manjo.